to refer to any of the confidential numbers, let me know, and we'll just do a quick turn off on that point. So we back, um, are we back on, or?
I've hit the live button. We should be back on the record.
Okay, all right. So, Mr. Green, go ahead.
Thank you, Mr. Chairman. I'll do this from a very high level, and if
Yeah.
anyone from
Sure.
any side wants me to add detail, I'm happy to
Okay.
do that. So the first thing that I did was explain how we got to $3 million as we have moved in our motion that requesting the penalty be modified, or the refund and penalty provisions be modified. The second thing that I did was respond to the what I think are either misinterpretations or misunderstandings or misrepresentations of the company's financials, which Smart Energy provided to OPC and staff within the last several months. The first of those dealt with the allegation in staff's testimony or staff's opposition to the motion that the members of Smart Energy's salaries increased in the last couple years beyond a reasonable amount, and that the members were essentially pilfering money out of the company. There were three responses to that. One had to do with the compensation or the salary and bonus structure and the timing of those payments, which spill into 2024. So if you extrapolate 2024 out to the full year rather than the first 5 months, the numbers for 2024 will be equal to what we have seen, or in the same ballpark as 2023 and 2022. The second thing is an explanation that there were two shareholders or members who left the company, and pursuant to the terms of their employment agreements, they had call options which had specific buyback amounts of their shares, and the company was able to negotiate with those members for a buyout, if you will, that was less than what was in the employment agreement. And then the third is that, excuse me, throughout the last several years, the financials and the narrative that accompanied the financials show that the members loaned a significant amount of money to the company every year for either 6 or 7 years. I don't remember. And then at the same time, during at least 3 of those years, they did not take a salary. And then in 3 of those years, they did take a salary, but essentially ended up loaning the money right back to the company. And then I explained the loan repayment from 2023 to the members that was basically on a loan, the loans that started 10 years ago that had not been, the principal of which had not been repaid at all in any amount since then. Next, I explained the entries in the narrative pertaining to tax payments made to tax authorities for that the entity made, or so distributions that the entity made to the members to pay their taxes, which is common among LLCs and S corps. And then also the change in law in, I think, 2019 with the TCJA, which allowed the entity to pay the taxes directly in the state level in some states that changed their laws. And then finally, I responded to OPC's statement that the financials and the other information that Smart Energy disclosed prior to today do not fully cover the transactions or relationship between Smart Energy and its subsidiary Smart Direct, which is a Dominican Republic company, and that the audited financials are consolidated financials. They include all of the financials from Smart Direct, and that at no point did Smart Direct ever make any payments directly to members of Smart Energy, that pursuant to Dominican Republic law The Smart Direct charges their cost plus a nominal margin, and all of their, again, expenses, liabilities, assets, so forth, are all included in the audited financials that we produced, as well as, I believe, staff asked in discovery, and it's attached. The discovery questions are attached to OPC's filing as an exhibit. That we produced all of the checks that went back and forth between Smart Direct and Smart Energy to show that there was nothing nefarious or out of sorts going on. I believe that covers it. If I need to say more or go into detail about anything else, please let me know.
Okay, Mr. Fields.
Thank you, Your Honor. First, I'll start by asking the Commission to note that part of the company's presentation here, and maybe the heart of it, was to impugn the work of staff and OPC in this case, and well, I think you should take note of that. Our work here resulted in a commission order of finding of after extensive litigation, days-long hearing. Company was able to present whatever evidence they wanted, make arguments that they wanted, many of which they're still making today, and there were findings against them. Both by the Public Utility Law Judge and by the Commission, in an extensive written decision that's then been appealed through 3 levels of Maryland courts. Maybe it's headed down to district court as well. So I think it's noteworthy that what they're left with now is to say that staff and OPC were doing things wrong in this case, and I'll leave that where it is. Second, I'm not going to delve back into the numbers. I think after Commissioner Barbay's questions, Mr. Green said that they responded to the points in our letter. They didn't respond to the point about the net profits. I won't get into the numbers, but I think it demonstrates that they have chosen over the years not to prepare for this, that they had this order directing them to make these refunds. Commissioner Richards' questions about, why do you keep calling this a penalty, I think are right on point. This is a refund. Most of the discussion here today would be reasonable discussion in the future hearing about their civil penalty, but it's not and should not be relevant to the refund determination. They've chosen not to be prepared for this, and now they're in the situation they're in. All of this, puts the Commission and the other parties, and I mean, it's kind of a heads I win, tails you lose kind of situation. The company came to Maryland, even though they'll never acknowledge it today, but the findings were clear. They sent deceptive postcards to millions of Marylanders. We had we got the postcards. They were in the record. They were right there for everybody to talk about. Public Utility Law Judge found they were deceptive. The Commission found they were deceptive. No court has had any problem with that decision. And that was something that the company did. Talking about intent of the company. This wasn't just some rogue employee or a call center or something saying things they shouldn't have said. That certainly happened, and it was all over the 34 calls that we have in the record. But that was that was the company's business practice. And then we had the sales the sales scripts. Commission found there were multiple problems with the sales scripts, misleading and deceptive. Again, that's, we're not talking about people going off script. We're talking about what the company told these folks or wanted these folks to say to Maryland customers, and that was deceptive and misleading. And that I'm not saying. I mean, we did say that, but the commission agreed. And those are findings. So to talk about intent, I think it's just it just goes completely the other way. And in the other cases that they like to talk about, the commission makes decisions case by case based on the record, and I don't want to get into a whole litany of all those other cases, but here you have findings based on documents, based on the evidence of deception and misleading of customers that affected every one of their transactions with Maryland customers, and that is, completely, substantiates the decision that all of the customers are deserved a partial refund. It's a little, the language can be a little confusing. It's a full re-rate, but it's the difference between what they charged in SOS. The commission didn't ask them to give back every dollar they charged Maryland customers. They said give back the difference. That adds up to a lot of money because it's a lot of customers that they did this to, and it's they charge them at certain times a lot difference between what above the SOS, so that adds up to a lot of money. But we're in the situation now where it's a little bit like the customers who received these postcards and were unfortunate enough to call this company. It's sort of catch me if you can. We heard about how we gave staff and OPC all these financials, and here we're giving them to the company, and we gave them everything we asked for. What about the things we didn't know to ask for? What about all the other issues that you can have with these financials? I don't think the commission should take them up on that and come to conclusions about the company's ability to pay, or that it would be reasonable to excuse them from this remedy. I mean, even here today, we heard Mr. Kern is here to talk about the financials, and he said that Commissioner Barve might know more about the accounting than he does. So the idea that you really should feel confident that you're getting a full picture of this company, I think is pretty shaky ground to make any assumptions about that. I'll try to wrap this up. So I think I'll just go back to the basics. This case started with a set of complaints, and staff looked into it. We looked into it. We found the documents. We got the tapes of the calls. There was deception throughout. We put on that case with a lot of time, a lot of expense. Commission resources had to be put into it to make these decisions, and this has all been litigated. And like I said, if all of this discussion, maybe it's relevant to a penalty sometime in the future, fine. But as far as taking all this to excuse and say that they don't have to pay the refunds for for their conduct that the commission has decided, I think the commission should not entertain that, and as Mr. Wolfson said, as we said in our letter, direct them to start making the refunds, to start get that audited, make reports on it, and get that started with an absolute time frame and direction to do so.
Okay, questions for OPC? Either one?
No, I think, Mr. Field, you summed that up very well, at least how I remember it. At one point I wanted to to ask you about is, I think in your filing, you do mention that, you know, at some point in time when the company began to seek, you know, to get this addressed in the courts, they did continue to do business. Is that correct? Did they continue to build the liability even after our order?
Well, after your order and the motion to stay, so part of the motion to stay was staying the direction to return customers to SOS. So they retained the customers, and you know, at that time, you know, they told the commission and the courts that the refund amount was $6.5 million. Although we didn't have any spreadsheets, any numbers about that. That's just what they said. When we actually got the spreadsheet, you know, we put this in previous comments. At that time, if you add up, you look at their spreadsheets and add up all the months up until that point in time, it was actually 10 million something. But then, since then, they were able to retain those customers because they didn't transfer them back to SOS until a couple years or so later. From that time till then, the refund, obviously they were charging on average more than SOS, so the refund obligation has now gone up to about 16 million, from 10 to 16. That happened since since the stay was ordered, you know, shortly after the commission's findings.
Okay, so even after we ordered the refund, they continued to build a liability
Yes.
in that refund account.
With existing customers. I don't have any information that they added customers when they shouldn't have been. But
Okay.
with the existing customers, they added up, the liability kept going up.
Great. Thank you very much, Mr. Fields. Thank you, Mr. Chairman.
So the question I have is that, you know, this situation reminds me of the famous Japanese movie where an incident happens and then they talk to people afterward and everyone has a different viewpoint about what actually happened. And so the company's implied that, you know, this is kind of much ado about nothing, that there really weren't that many people harmed, and as they've tried to do their arithmetic that way. So for the benefit of Commissioner Barve and Suchman and myself, who weren't here when the initial decisions were made, I mean, what is the harm that, in your view, this company did to Maryland customers?
Sure. Thank you. Well, you know, it's all laid out pretty well in the commission's, you know, order on exceptions. I'll summarize it. They sent these postcards to people. The postcards looked like the commission found they looked like they came from BGE. They talked about, because you're a BGE customer, you're eligible to get this price protection plan. You know, they you know, that misled customers into thinking that you know, that they were going to just call this number, that they were calling some part of BGE, and they were getting some kind of deal. You can hear that in some of the phone calls that are in the record. So that's kind of step one. Then you know, the commission found that, you know, telling people there was and that they were going to get a month free electricity. And so the combination of saying it was like a price protection plan and that you were going to get a free month, well, for a lot of customers, if they, you know, agreed to this, their rates actually went up. So that's not price protection, as the commission found it. And then, you know, the fact that the free month, you actually had to be on service and that for like 6 months, and then, you know, send in a rebate form or something like that. And they didn't, you know, accurately, they were misleading in how they described that. And then, you know, when we looked at the sales script, then you know, there were problems with that that are laid out in the order as well. And then, actually listening to the calls, there was instances of deception and not answering customers' questions, and customers saying, I don't want to, I don't want to change from BGE. I'm not changing from BGE, right? And the person said, oh yeah, you're fine. And then they switched them. You know, that is a, you know, specific call or rep situation. But you get into overall supervision and that sort of thing. But it's really the relying on the documents to say that this impacted all of the customers. So the fact that you had 34 complaints. I mean, if you do a good job at deceiving customers, they're not going to call and say I was deceived because they don't know. And they're certainly not going to call and say I was supposed to get a contract summary under COMAR 20 point, whatever. They didn't do that for years. There's some other violations about putting their license number on the marketing material and that sort of thing. So the real underlying harm here is that they deceived customers, told them they were going to save money, and as we just see from the numbers that people didn't save money, they got charged $16 million more. I mean, those are Maryland customers. I don't have any information on where they are on the income scale or any of that. It's probably all over the place, but that's $16 million that they that they paid that they shouldn't have paid because they didn't weren't told what the offer really was and were misled into getting into it. The fact that they when we looked at their documents, when we realized that they didn't have any signed contracts from any customers, that they were doing this over the phone, and then we asked, or staff asked, well, what about the signed contracts? Well, we don't have any of those. We have these tapes of phone calls. There's parts of the commission's regulations about the Maryland Telephone Solicitation Act, and we looked at it and said, well, this is a violation, and the commission and all the courts have agreed. So I mean, Mr. Gandler's still arguing today about how all of us are wrong about that, but that's what the Supreme Court said, that it applies. If the company got some conflicting information from CAT or somebody else, that doesn't change the law. Maybe it changes what the penalty might be, the actual civil penalty. But when you have this level of deception going on in their whole marketing scheme, it is up to the commission. But I think it's pretty clear from the original order 3 years ago that that's a critical factor in deciding that the refund should go to all the customers instead of just a few, and we certainly think that's the right decision, and that the commission should stick with it. I went on for a while. I hope I hit enough to answer your question. If you have any more specific questions, I'd be happy to answer them.
Okay, Commissioner Barbe.
Actually, I think I'm not going to ask the question because I can't remember if it is rooted in the confidential portion, so I'm not going to ask my
all right,
question.
fair enough. So, Mr. Wilson.
Yes, I'll try not to repeat Mr. Fields' accurate argument. Commissioner Richard, it was 100% correct. The MTSA was only a small part of this case. And it's a red herring that they keep bringing up over and over again. I like Commissioner Richard and Mr. Fields and Mr. Green, well, actually, even before Mr. Green got involved, was involved in this from the beginning. And the MTSA wasn't even a part of the original complaint. That was added later as through discovery we realized that there weren't the signed contracts. And that was added later in an amendment. And when Mr. Frisbee recited what happened with the original Public Utilities Law judge finding the MTSA did not apply, that's correct. But she's the one who fashioned the remedy that included all the refunds. So she ordered the refunds, which were subsequently upheld by every court without the MTSA. So the refunds are not dependent on this MTSA angle that we hear over and over again from Smart Energy's attorneys. And I'm sorry to say that Mr. Frisbee, who was also not involved in the early parts of this case, nothing he said struck me as being correct until he got to the telling words, "We lost." And that's exactly what happened. They lost. They lost here. They lost in Montgomery County. They lost at the appellate courts and at the Supreme Court. And on every level they lost. And still they're regurgitating the same incorrect arguments and misinterpretation of what actually happened. As far as Mr. Green goes, he and maybe I was not clear in my pleadings, the reason I added the gross revenue filings was something that, again, that's something that Commissioner Richard brought up. It was to show that this company, even after the refunds were ordered, while it was on appeal, made no provision while they continued to take in gross revenues. They made no provision for what eventually came to be, was that we're here seeking to recover those profits, those refunds. And so they were continuing to profit at whatever level, 3.2% or 40%, we don't know, in Maryland, knowing that they were facing this contingent liability and made no provision for it. And the same goes for why I included the increase in salaries and the bonuses, because it was business as usual, even though they had this huge contingent liability to Maryland consumers that they ignored. And now they're complaining that they increased their liability from what they claimed was $6 million, may have been $10 million originally, and it went up to $16 million. And now that's supposed to be borne on the backs of Maryland consumers. And finally, Mr. Gansler, who suggested that the commissioners were not here in 2019, and I can only say neither was Mr. Gansler. And Mr. Gansler has demonstrated that he has very little knowledge of what this case was actually about and what occurred in this case. He said that there were only 32 complaints and nobody was harmed. He said one person who was defrauded. And yet he also said that we sent out 6 million postcards. Well, that was 6 million people who the court determined received fraudulent information. That was 6 million violations of Maryland code. He fails to mention that summary judgment was granted on approximately 32,000 violations of failing to provide the contract summary. And there's testimony in the record from Mr. Kern that he was aware that those contract summaries needed to be sent out, that were required by Maryland law, but decided not to send them out for whatever reason.
That is
Objection,
totally
Your Honor.
inaccurate.
Wait a minute. So this actually isn't a rate case. So I will give you guys an opportunity to respond, but I'm going to let him. I let you guys talk. I'm going to let him talk.
I hear you.
So,
Sorry.
Sorry.
And that nobody was defrauded clearly, Mr. Gansler hasn't listened to the hundreds of solicitation tapes that Mr. Fields and I have been subjected to, in which there was violation after violation after violation. Now, Mr. Kern's sister, who was charged in the company with dealing with complaints, later admitted in testimony that she didn't always listen to all the complaints, the tapes. She would just send out, at times, a response denying that the calls were improper to CAD. And so I think they've demonstrated that they're not really aware of what happened in the years that we were pursuing this case. So other than that, I adopt everything that Mr. Fields said.
Okay, any questions for staff? So let me turn back to smart energy, but here's what I want. I'm going to give you a chance to respond to what you've heard, and however you want to respond. But I don't necessarily want all three of you to do it. So you can decide. I'll sort of take it at two. If you think that there's enough distinction between what was presented by Mr. Frisbee and Mr. Gansler, as opposed to what Mr. Green talked about, that's fine, or just one. But I don't want to hear from all three. But go ahead.
Understood. Why don't you go ahead?
So I'll start,
Sure.
and I think I'll be brief. I understand.
Actually, is your mic on? Because I'm having trouble hearing you.
Far away from it.
Sorry.
Yeah.
Is that
Okay.
better?
There you go.
Sorry about that.
Yeah.
I understand. I was the first of the lawyers on this side of the table to be in the case. I understand there were, I think it's safe to say, with the exhibits, over 10,000 pages of documents filed from all the parties, with including all the, maybe not 10,000, but thousands of pages from various witnesses in the company, and I understand that facts can get messed up along the way and that we're all hot right now, but I want to just set a couple things straight. And I'm not trying to relitigate, I just want to make sure that things are correct. OPC and staff asked for, and the company provided, a total of approximately 45 telephone recordings. Of those initially, and this is testimony from Kevin Mosier in the case, 18 were part of the CAD 34 complaints. So I think it was 18, but 18 were found to have problems, right? And Jackie Kern admitted that they were problematic. The company had a quality assurance program. I believe they reviewed, it was either 5 or 10% of all the calls. Those 18 weren't randomly selected, so they would have failed. But that was the testimony in the case. The second thing about the contract summaries, staff filed a motion for summary judgment. Our response to that was to admit, as Mr. Frisbee said, that the company had not sent contract summaries. They didn't realize that they hadn't sent them until after the complaint was filed. And I can tell you, because I was in a meeting with Mr. Wilson and other folks when we found out that the company realized that we hadn't sent contract summaries. The company, sent them with a letter that said, we messed up, we didn't send, I'm paraphrasing, but we should have included this, we didn't, and you can cancel at any time. And then second, as we said in our testimony, there was no intent to not send the contract summary, because if you look at the welcome letter, most of the elements that are in the contract summary, the price, the duration, all of that is all in the welcome letter. So what happened, and what the testimony said, and this is where we got a little riled up 10 minutes ago, is that Mr. Kern did know that a contract summary was required, and the testimony was that he simply messed up, that there was human error and he didn't forward it to the printer. So when all of this stuff happened and when the sales kicked off, It just didn't, the mailings that went to the customer after the phone call did not include a contract summary. And no one at the company realized it until the complaint was filed and we had the meeting with staff. That's how it happened. There was no intent to not send anything or to hide information with respect to what's in the contract summary. That was the evidence in the case. And then the last thing, I'll just add this, because my job today was to do the financials. And we've talked about the facts of the case, who held what, circuit court, Supreme Court. The fact of the matter is, you can say 16 million and come back later for a civil penalty. The financials, the objective, audited financials show that the money's not there. And like we said in our motion, you cannot draw water from a rock. So you can do this under the guise of punishing the company and sending them out of business, potentially. But that will also affect customers. So like we said in the motion, we realize that 3 million is not 15.97 million. We understand that. But if the 3 million is adopted, customers will get some money. We can talk about subsets of customers that get more money other than others. But they'll get some money and they'll get it faster than if there are potential bankruptcy proceedings down the road. And there's also things that could potentially be subject to clawback that are totally beyond Smart Energy's control. There's a stay, there'd be a bankruptcy estate, there'd be a trustee, there'd be filings and claims and so forth. And at that point, Smart Energy, as I understand bankruptcy court, is more or less out of it. And the chips fall where they fall under the priority payment posting or payment system. So I think that's.
That's very. No. All right, just to directly, because response is obviously the second one. Mr. Wolf said we are impugn, or somebody, one of them said we impugn the staff in OPC. I would never impugn any government worker. I was in government for 23 years, and what I do impugn is government workers that are not straightforward, honest, and present the facts clearly, and then selectively punish somebody. All I'm saying is, in one case they're saying we want $32 million, and in a similar case they want $125,000. Something's wrong there, and that's what we're pointing out. And the idea that Smart Energy was not prepared for a penalty, in the similar case where $125,000 was meted out, there was a bond in this case for $2.5 million plus the $250,000. So that's like 25 times the sort of maximum amount. What they had they lost, which they did, they would have been prepared to pay, because that's what everyone thought they would be prepared to pay, and that would have been an enormously high number. They said it started with a set of complaints. There were 6 million postcards sent out. There were 32,000, there were 104,000 calls, 32,000 people signed up. There were 4 complaints. That's how this case started, 4. Then there was discovery done, and it got up to 34. And 18 of those, we talked about the scripts. That was somebody that went off script, clearly. And when they sit here today in front of you, the commission, and say, we listened to the hundreds of tapes, and there was violation after violation, they had 45 tapes out of 34,000 calls. That's what and they didn't ask for more. We gave them what they asked for, and we could have done more. I appreciate, and answer your question, Commissioner Richard, they kept their customers, but they did not add new customers immediately. So I'm not sure that was perfectly clear. And while I appreciate Mr. Wolfson telling me I have very little knowledge about what this case is about, I have 1,000% knowledge about what this case is about. I've read every word, I've been involved in every piece of it. And while I don't agree with what the Supreme Court in Maryland did, in this case vis-a-vis the MTSA, because it's inconsistent with the 49 other states plus D.C. plus the federal government, I also don't agree with Citizens United that a company's a person, or Heller that the militias can mean you can actually, in the Second Amendment, you can shoot people. I don't agree, and I think that'll be borne out over time. But it doesn't matter. What matters, I think, Mr. Chairman, you asked the right question. You said, well, what is the harm? And the fact that Mr. Fields talked for 10 minutes in response shows there was no harm. The short summaries were sent. They operate in these other states. Most states don't have the short summary. They messed up. They sent them. They got the information in the welcome kit. They got the information on the script that was approved by lawyers before being used. And when the commission gave them the license, they would have arguably looked at the script before they licensed them, and they did. So there was no harm to anybody here. And they're still willing to pay $3 million as opposed to the $125,000 or the $150,000, the two companies that had comparable situations. So it just doesn't, we're not asking for any favors here. We're just asking for the right thing to be done. And they're not happy about spending $3 million watching their competitors pay $125,000, knowing that they've already surrendered their license, there's no jurisdiction anyway. They're willing to do it. And it just seems it's in the public interest and the interest of everybody to put the case aside and resolve it with that amount of money.
Okay. Any questions? Commissioner Barbe?
Thank you, Mr. Chairman. Mr. Green, just so that this is stated succinctly on the record, your client, we received audited financials for 21, 22, 23. Just want to hear it on the record. Your client believes that those audited financial statements fairly state the financial situation of the company under the rules of generally accepted accounting principles.
Yeah, Matt, Mr.
Sure.
Kern answer it.
Yes, sir. And with reference, first, by the way, with reference to the statement made by, I just want to acknowledge, you definitely know your way around a financial statement. I have an undergraduate degree in accounting. The financials were all reviewed and audited by public accounting firms.
Okay.
And the two stewards, financial stewards of our company since we started, one had a master's degree from Stanford, one had a master's degree from Yale. I had, I believe, very solid people, both internally and externally, relying that I could rely on to produce accurate accounting.
Okay, well, I only graduated from Georgetown with a B- average, so I just want to hear officially that you and your company accept that these fairly state the financial condition of your company under GAAP.
An emphatic yes, yes.
Okay. All right. Second question, and again, Mr. Green, I apparently this was stated in the non-confidential section. It's been stated again here. Why is the comparison of a finding between one case and another case relevant? If, for example, in this instance, we find this company 6 times or 30 times or 2 times more than another company, why is that a relevant argument?
Because it's an issue of fairness, and we're looking at, and especially in my practice, we represent so many different suppliers, and I'm looking at, well, this supplier had people out misrepresenting themselves as employees of the commission or, associated with a utility. And we move to settlement, or it goes to a fully litigated case, and there's a resolution that is significantly less than what is being imposed upon Smart Energy. And so there's just no comparison. And then you move into constitutional issues, which is the product of the Federal District Court complaint that was filed Monday. But so there are just it is utterly inconsistent as between what's happening to this company, and if you look at some of the worst players in Maryland history, so to speak, the Sun Seas, the Smart Ones, those did things that are way worse than what Smart Energy did. And then you look at what has happened with some of the other suppliers that we've mentioned today. Again, that conduct on par or worse, because that was actually face-to-face contact with human to human, face-to-face, and yet the commission is either litigating, resolving, or accepting settlements with outcomes that are unbelievably different in the same time period. So at some point, if you're Smart Energy, you have to sit back and say, why am I being treated so differently when you look at the conduct? And that's I think that's the relevancy, and I hope that answers your question, because from our perspective, we're looking around and we're saying, what the heck is going on here?
Now, and a final thing. So, of course, and I am new to this case. The only veteran here is Commissioner Richard. But
Apparently it drove the other four off.
oh yeah, sure, that's what it was.
A few more months.
But really, the question here is the difference between SOS and what your client charged. I mean, that's really all that's in question at this moment, correct?
Yes and no. Yes, because that is the refund amount.
Right.
And then no, because under the order that the commission entered, I think 3 years ago, the company is to pay the refunds and then come back and be subjected to
Right.
a subjective
Possible
civil penalty.
Civil
right?
penalty.
So we don't know
right.
what that number is going to be.
Okay, but we're not. But this is basically the issue in question is the differential between standard offer service and what your client charged.
That is the refund. I just want to be really
refund
really
portion.
clear on this. Is
Yeah.
that in our motion we said we can pay $3 million. Like that's what we're pushing to the center of the table. So that however you want to break that down between refunds or civil penalty, but we can't pay $3 million and then come back in however many months and agree to or somehow be subjected to another $1 million or whatever it is. And I will say this, that on the $3 million, just in case you didn't pick up on this in the motion, we recognize that people move, checks will be uncashed, returned to sender. So we would keep an accounting of the $3 million, and if say $2 million was cashed but $1 million was not, then after a period of time, the company would write a check to the Maryland Energy Fund to assist low-income customers. So we would be all in for $3 million. It wouldn't be, $2 million because $1 million didn't cash the checks. So I just wanted to make sure that that was out there on the record today.
Well, the reason I asked the question about the differential between SOS and what your client charged is, to me, that appears to be the only relevant number, not what might have happened in a different case. That, to me, that differential is the relevant root of the issue. And all other comparisons between what might have happened in the past or in what you say are similar situations for me, is not relevant. For me, the relevant number is that differential.
Right.
For the refund.
It is relevant, but right. There were other. It's relevant to the extent that there were also other suppliers that engaged in similar or worse conduct who didn't have to pay refunds. The commission specifically held that Sterion, North American Power, Viridian, Blue Pilot, these engaged in similar or worse conduct, right? Sterion had they admitted on the stand, we don't know how many phone call fraudulent misrepresentations we made. It could be over 10,000. They didn't have to pay refunds. So yes, the number is largely driven by the difference between SOS and I should say SOS down here and the Smart Energy price up there. And that Smart Energy price, frankly, is also driven by the fact that a lot of these customers were on variable pricing, and Ukraine got invaded and prices went very high. So you have all of those things. But when I make those comparisons to other cases, we also have to realize that there were other suppliers that didn't and don't have to pay refunds. And the commission either approved a settlement on that or they litigated it.
And all of those cases were more than 10 years old.
That's not right.
Well, if I could just add
Some were, but not all.
one thing. I mean, I think Commissioner Barbe is right that trying to compare cases is really irrelevant. But in this case is different because we have documents that show deception of customers, misleading customers, misleading information for every transaction that the company did. And that's different from the other cases.
So I guess just to follow up on that, I mean, the charge for us sitting here today is to attempt to determine what this liability, refund liability, is going to be. Because a previous commission made findings regarding the actions that the company took and whether they were systematic things or whether they were actions of a couple of employees. And so that's, to my mind, that's like water under the bridge. A previous commission made those findings. You know, the commission's decision got appealed to the Maryland court system, and there was never any change to any of those findings. And so for our purposes, we need to determine what this refund liability is going to be. Now, accepting the truth of your first statement, which was you can't get water or blood out of a stone, you know, that's, in my mind, a different issue as opposed to what the actual liability is that we feel that this company is liable for. And so, you know, we've had this discussion today about, you know, sort of what it is, but I think there's been some conflation of the, you know, refund liability and a potential penalty at somewhere down the road that we might do because of based on intent and bad actions by the company and its leadership and things like that. We're not deciding that today. We're really just looking at what is this refund liability to the customers who got harmed by the actions of this company. And that's what we're going to have to decide going forward.
Your Honor, respectfully, I disagree. I think that this commission does have the right to look at the situation in its entirety and take into account the entire situation in making its decision. And I think it should take into account the ability to pay. Are customers actually going to get something soon or never? Those are all, and also they can also look at the record and look at exactly, yes, we never said there weren't violations with regard to the with regard to, say, the contract summary. We admitted that. But it can take into account that. It also can take into account, quite frankly, that this case dragged on because it was a test case. And the commission wanted, quite frankly, a judicial decision with regard to the MTSA. And that's why everything else settled and this one didn't. I think the commission can take that into account.
Okay, well, as I said at the beginning, we're going to take this under advisement and we'll get something out in due course. So with that, we're adjourned.
Thank you, Your Honor. Thank you.